NACDL is the association of the nation's criminal defense bar.
Well, thank you guys so much for having me, and thanks most of all to the fearless Jeff Robinson, who is our leader, our mentor, and our chief as we all work to fight racial injustice and injustice in the criminal justice system at the ACLU. It is invigorating and so meaningful to have a leader who's actually defended people in the criminal justice system and totally gets that this is not just a system that we need to reform, but one that really is a lens for viewing structural racial inequality, economic injustice, and deep-rooted problems that actually attack the core values of equal protection under the law and dignity for all people in this country. So thank you, Jeff. Thank you also to the NACDL and the ACLU for putting this great two-day conference together. I wish I could be here for all of it. I think there's so much to learn and so many great people in the room doing work on all of these issues. These are the conversations we need to be having to make sure that we're all civil litigators, public defenders, on the same page and keeping our eye on the prize in terms of what we want to do to actually make total system change. Thank you to Rick Jones, president of NACDL. Thank you to Norman Reamer. Thank you to Cynthia Rosenberry, Amy Capinelli. This is a fantastic opportunity, and I'm really grateful for the chance to talk to all of you guys a little bit about the intersection of race and poverty challenging debtors' prisons. I want to talk for a little bit just about things that I assume everyone in this room knows a lot about. Because if you didn't, you probably wouldn't be here. And that has to do with the fact that if we're gonna have a conversation about racial and economic injustice in the criminal legal system, we must know and acknowledge that at the root of these injustices is deep-seated, implicit, and explicit bias against people of color. That kind of bias is real. It is recent, it is also longstanding, and that's a lot of what is animating these systems. So we're gonna talk a bit about some of the challenges, some of the progress, some of the existing opportunities for public defenders to actually make a difference in challenging a phenomenon that we call debtors' prisons, the unlawful jailing of poor people simply because they don't have money, and other collateral consequences like suspension of driver's licenses, and resulting limitations on people's ability to live full and equal lives. We're gonna talk about this problem, we're gonna talk about what folks can do about it, but really at the root of this series of issues we're gonna talk about is the fact that there's racial injustice. We know that. We know a lot of the criminal legal system was created to perpetuate or enable that. We also know that there is a huge decades-long transition in this country from funding public services through public dollars to trying to collect that money to serve essential public services from people involved in the criminal legal system who are disproportionately Black and brown. And we also know that in this mix are for-profit companies that want to make money. And they're trying to do it because they're seeing this confluence of revenue generation through the justice system itself, and also that it is impacting folks who are marginalized and don't have the political power to resist that kind of trend. So I just want to put that out there, that at the root of what we're talking about, these problems, is race, is revenue generation through the justice system, or some might say the criminal legal system, and also profit-motivated actors. And all three of those root causes are animating what we're going to talk about today. So you guys have before you if you have your packets out, I put together a curriculum, and we're gonna follow that curriculum loosely, and we'll see how the conversation proceeds and where folks want to spend more time. But basically, I think those of you who work in courts see, and you've seen throughout your careers, this rise in, quote, user-funded justice, right? The fact that in the state of California, a $100 fine in a court, whether a misdemeanor offense or a felony offense, is usually associated with 3 times the amount in costs and surcharges, assessments. The words are different in different places, but basically what they do, those costs, those surcharges, those assessments, is try to recoup the cost of the justice system itself. Things like, as you all know, public defender fees, right? Court costs, warrant fees. Sometimes there are prosecutorial fees. Sometimes there are courthouse building fees. You name it, they're in there. I think California is one of the most egregious examples, but even in the state of Mississippi, a simple traffic fine will always, at a minimum, carry anywhere from $89 to $125 in surcharges. In the state of South Carolina, when you look at their fine schedule, it's hilarious because when they call it a fine and you actually look at what people are sentenced to, every fine is comprised of at least 50% costs and surcharges and assessments. And what this is a result of, as so many of you know, and so many of you are actively working to challenge, is the rise of mass incarceration, right? Like this kind of criminalization of low-income people, of people of color, funneling them into the justice system and into prisons, and then having to pay for it and not wanting folks to pay for the justice system with public dollars. But this is the reality of where we are now, is that in most courts, even for minor offenses and going all the way up to the most major offenses, we know that folks are getting saddled with so much debt. And a lot of that debt is money they just don't have and never will be able to pay. And what that's leading to, and there are stories that we've all heard of across the country, most notably in the city of Ferguson, that folks are getting jailed because they don't have money, that a lot of that money actually goes to even fund local government or fund for-profit companies, and this is totally trampling on people's rights in ways that would make anyone who's a public defender be just like aghast at how the right to counsel is being trampled upon in these situations, right? Incarceration is happening. There are no lawyers in the room. In some places, like in South Carolina, in almost all low-level courts, the judge isn't even a lawyer. There's no defender in the room, and there are no prosecutors because police officers actually prosecute cases. And so you're seeing in certain places, the practice looks a little bit different in different places, but the end result is the same. Folks involved in the criminal legal system are getting charged for costs and surcharges in addition to exorbitant fines they cannot pay, and the result can be jail. It can also be suspension of a driver's license, since many, many states have statutes that permit or require the suspension of a license when someone can't pay fines or fees for another offense, and it can also lead to collateral consequences. In some states, like Georgia and Connecticut, you can lose your right to vote if you have unpaid criminal justice debt. And that's just the beginning. We know that it impacts people's credit scores. We know that then people can lose their housing, have trouble applying for jobs and getting jobs, and the list goes on. And you all know this as public defenders. So that's like the overview. Throw into this mix this really toxic entry of for-profit companies. And one of the areas in which it's been the most notable is for-profit probation. So because of mass incarceration, because so many people are funneled into the criminal legal system, and then the legal system, quote, has to pay for itself, thereby kind of charging people in the system for those costs. When they can't pay, jurisdictions have, in numerous occasions, relied upon for-profit companies to then collect those debts using this mechanism of probation, which is really crazy because probation traditionally was thought of as being, you know, a way to release someone so they weren't incarcerated while they had some community supervision because the court decided that they needed some kind of supervision, right? Here, we're talking about probation for debt collection. It's really just debt collection. And you see companies like Judicial Services, Sentinel Offender Services, Pinnacle Probation Services is another one in the South, where they're just processing people and calling folks in for meetings that result in like basically 5 minutes of interaction saying, do you have the money or not, based on the amount of money that someone's supposed to pay. We're gonna talk a little bit more about the abuses and how terrible those systems, the kind of violations that those kinds of systems can lead to because of the profit incentive. But that's also kind of part of this backdrop. So part of the challenge in doing something about all of this has been at its root cause that courts and court clerks have gotten used to this idea that, oh yeah, we have to collect money. Otherwise, we can't keep our doors open. We know the legislature will not give us money. We know the city council will not give us money. So there's this kind of complacency about the user-fundedness of the justice system. And there's also been historically in the US, as many of you know, since the civil rights movement of the 1960s, barrier after barrier after barrier being brought to actually bringing constitutional challenges to vindicate rights in precisely these circumstances. We see in the 1980s, we see in the 1990s, we see in the early 2000s, federal appellate courts, federal district courts, one after another raising obstacles to bringing lawsuits that would challenge local courts and judges who jail people who don't have money. And actually, these cases actually go way back. If you look at the Prohibition era in the 1920s, there are a series of cases coming out of Ohio. Ohio has, and today continues to have, these courts called mayor's courts. They're not under the jurisdiction of the Chief Justice. They are local fiefdoms, and they raise revenue for their municipalities that they're attached to. And in the 20s, what they were doing was trying to raise money out of enforcing prohibition laws, throwing folks in jail because they had alcohol. And part of those monies that they collected went to the mayor. And so in a famous case that went to the Supreme Court called Toomey versus the State of Ohio in 1920s, the Supreme Court said, when you have a decision maker in the justice system that is profiting off a decision to charge and convict and incarcerate someone, that creates a conflict of interest that violates the core principle of due process that's embedded in the Constitution. You can't do that. And it was much easier to prove in the 20s when literally the money was like lining the pockets of the judges and the mayors. What we've seen is an evolution since then of more indirect ways of funneling this money to justice system actors. So you see, for example, in the city of New Orleans, that the public defenders, the judges, the prosecutors are all funded by the fines and the fees that are collected in the criminal district courts. And you see this in varying degrees in other court systems as well. But there have been challenges to bringing federal lawsuits against these systems because they involve state courts and judges. And so there are doctrines of judicial immunity. There are abstention doctrines telling federal courts not to interfere when state court criminal justice systems are at issue. This idea of younger abstention, that when there's a pending criminal proceeding, the federal court should not get involved because it shouldn't interfere with the state's ability to enforce its criminal justice system. You see these doctrines arise, and actually just at an intellectual level, it's really interesting that they all arise in civil rights cases. The cases like Lucky versus Miller in the 11th Circuit, which is a challenge to Georgia's indigent defense system, is one of them. In these cases challenging conflicts of interest, you see those kinds of doctrines coming up as well. Challenges to bail system. In a number of cases out of Ohio, challenges to debtors' prisons, these towns that were jailing people who just didn't have money. In 1987 decision, the Sixth Circuit upheld the dismissal of a lawsuit that's just like the kind of lawsuits I'm going to talk to you about today. But back then, these courts did not want to hear those claims. And so they were just kind of kicking them out of court on these procedural grounds. So for all of these reasons, about 7 years ago, when the ACLU started exposing and challenging these practices in a report called Infra Penny, litigation did not seem like it was going to be a possible avenue for relief. There's so many doctrines challenging the ability to look at a city or a state that was unlawfully, blatantly, brazenly jailing people who didn't have money in violation of core constitutional rights to a fair hearing and to counsel. But getting into federal court to enforce it wasn't possible, and the state courts are often politically not the right place to go because there are relationships between those state court judges and the local actors. Or sometimes the court that you're worried about is a state court, because that's another thing we've seen in the last 30 years. A lot of local courts have become state courts in an effort to shield those courts from federal litigation under doctrines of sovereign immunity. Point being, in 2010, when the ACLU published a report called Infra Penny and exposed that people are being jailed because of their poverty in 5 states, Georgia, Louisiana, Washington, Michigan, Ohio. There's one more I'm missing, Georgia, Louisiana, Washington, Michigan, and there's 4, that's 5. In those 5 states, federal litigation didn't look like it was gonna be the greatest path. So part of the strategy was to name and shame and just show how unjust and how ineffective this was. And so the ACLU of Ohio, for example, put out a great report called Outskirts of Hope, chronicling the town of Hope, Ohio, where people were being jailed. And they were able to show that poor people were jailed for 20, 30 days. It cost dramatically more than the amount of the debt that they even owed, and it was against sound public policy as well as core constitutional values. We also tried in Michigan bringing direct criminal appeals, and it took a lot of strategizing to do that because, as you guys know, the appeal can be mooted really quickly if the judge just changes the decision to not incarcerate someone and to waive or reduce the fine or fee or kind of issue a sentence of time served. So basically, in 2011, the ACLU national office and the Michigan affiliate filed 7 criminal appeals together on the same day to make a point. They found 7 people in different courts who were being jailed. They were told by a judge, pay this amount of money or go to jail. Each person went to jail. Emergency criminal appeals were filed, and what it did was it raised statewide attention, and they did get those people out of jail, but there was no injunction or kind of permanent policy solution to kind of embed that result and require it across the state. Now, the attention did get the state task force. It got the state Supreme Court to create a task force, an ability to pay work group, which eventually, and I'll talk more about this later, led to the adoption of a court rule that's actually pretty great, requiring all the courts in the state of Michigan to hold an ability to pay hearing before a person is jailed because they can't pay fines and fees. But that took years. And we saw that there was a limit to what an individual direct criminal appeal can do. Like, those direct criminal appeals are so powerful. They can create really good law in that one person's case if that case can go up and it's litigated well. But there was this limit to kind of making that happen. Things changed in 2013, for us at least, because the Supreme Court came down with a decision, it's a unanimous opinion of the full court, authored by Justice Ginsburg, in a case involving the telecommunications company called Sprint. And it basically involved this dispute between private parties over telephone rate making. Really not interesting stuff, in my view. But the point of the case was that there was a pending state court enforcement action, and then one of the parties brought suit in federal court, and the question was, can the federal litigation go forward or not when there's this pending state proceeding? And the Supreme Court basically said, hold up. This whole doctrine of federal courts abstaining has gotten so out of control. It basically has been read to exclude any challenge to anything happening in state court, and that's not what this is about. What this is actually about is not interfering with a criminal prosecution, trying to subvert one individual criminal prosecution or a specific state civil enforcement proceeding or some kind of contempt proceeding. And this kind of just throwing out any federal challenge just because something's happening in state court is not okay, and that's not why we created this doctrine in the first place. And so that kind of opened the door, and a lot of organizations started thinking about filing some litigation, and we took this really seriously and basically spent a year thinking about what kinds of cases do we want to bring. And I think thinking through that, our view was we needed to bring cases on behalf of people of color because of the reasons that we talked about at the beginning, that racial injustice is so much a part of why courts can even do this and who is being impacted and then again sucked into the criminal legal system because they don't have money. That it had to be focused on addressing that part of the problem. And we wanted to go into jurisdictions where we could make some good law, not just on enforcing existing constitutional protections, like the right to an ability to pay hearing, but also establishing protections where they're not clear, like the right to counsel. And right now, the right to counsel, we believe, our reading of the law is that it is clear in almost every case in which a court seeks to impose actual incarceration or a suspended sentence on someone who can't pay a fine or fee. But there are some places where there's no clear case holding that, certain civil proceedings, and we wanted to kind of push the boundaries and establish that case law. What ended up happening was we filed lawsuits in a year against DeKalb County, Georgia, Benton County, Washington, and Biloxi, Mississippi, and to our total shock, all of those cases settled within a time frame of 6 weeks to 6 months. So we had thought we were going to be litigating these cases up, and instead what we ended up doing was focusing on making settlements that we thought were as robust as possible, and I'll talk a little bit more about them in a while. But the point of all this, I go to all of this both because I think it's really interesting and it's nice for folks to know, but really to underscore how important everyone in this room is. Because civil rights litigation challenging the unlawful jailing of poor people, or the unlawful revocation of people's driver's licenses, or the unlawful, suspension of someone's right to vote just because they owe money they can't pay, is important to serve as a lever to push for total system change. But that just means there's a window and an opening and a need for public defenders and civil legal service providers who are representing individual people in individual cases to push the boundaries of the law in those individual cases. And what I mean is there's now a recognition around the country that these kinds of procedures are wrong, that they're immoral, and they're also largely unlawful. That gives space, I think, to public defenders who may have thought that it was normal for these kinds of fines and fees to be imposed and collected, and maybe for jail to result, to realize, you know what? We need to stop this now. Like, at the stage of imposition, when someone's convicted and being sentenced, that there is an entry point now to challenge in a way that there hasn't been before. And that's exciting, because it means that everyone is part of the solution. It means that civil litigation has to happen. It means that judges have to change the way they view these fines and fees. It means that public defenders need to raise arguments they've never raised before in certain jurisdictions, because they can move this in individual cases. And so that's really what I think the rest of my hour with you is going to be about. So basically, I'm not going to assume that everyone here has worked with low-income folks like my clients, and so I'm just going to take a couple of minutes to share some of their stories, because I really think that the humans at the heart of this show how completely distorted our system has become and why it needs to so fundamentally change. I think their stories highlight all of the perverseness. And I'd like to say that it's hard to find my clients. It's not. Like, we base it in any state we go into, we find clients. There has not been one state where my colleagues and I have gone to where we have not found what one would call model plaintiffs. And, everyone has rights. This is illegal for anyone, but it's not even difficult to find people whose stories are so outrageous that they make you think our legal system has been hijacked for the purpose of extorting people who are too poor to pay money. So I'll start with I'm going to talk a little bit about South Carolina and Georgia. I'll talk actually about Georgia first, because that was the first case I brought, and I think in some ways, it shows how there can be some systems in place that have the semblance of normalcy, and then you look closer and you realize it is anything but normal. So, in general, the burden of fines and fees is huge, and I think in the fight to prevent long incarceration sentences, there's been, over the past few decades, more unjustified tolerance for the imposition of really high fines and fees. And part of it is because folks are well-meaning public defenders have wanted to avoid jail by asking for or encouraging their clients to agree to pay fines and fees. And that's not necessarily a bad thing. Like, it's coming from a good place, because we are a society that has moved increasingly towards incarceration. And judges too. There are judges who've been thinking, well, I'm not jailing someone. I could, in the state of Georgia, jail someone for speeding 25 miles over the speed limit, but I won't. I'll impose a fine instead. But the burden of those fines is huge, and I think our client, Kevin Thompson, really shows why that's the case. So Kevin was 19 years old when we met him. He had been driving during the ice storm that hit Georgia about 4 years ago. Is anyone here from Atlanta? Did you live through the ice storm? Yes, there was an ice storm. It was really bad. So he was driving through the ice storm, and some roads were barricaded. So he took a left turn he shouldn't have taken. He thought he was supposed to because the road was barricaded. He gets his ticket, his first ticket ever. He's 19 years old. He goes to court. He is 1 hour late to the Atlanta Municipal Court, and they charge him with failure to appear, even though he was there for his individual hearing, pled guilty, paid a fine. He had an FTA. That FTA carried a $100 fine, and he paid it, because he was like, yeah, I was late. I shouldn't have been late. I get it. I got to pay it. Paid the $100 fine. He was training to be a tow truck driver. So unlike most 19-year-olds, he actually had some income, and he paid that FTA fine in addition to the fine for not taking a wrong left turn. What he didn't know, and no one told him because he didn't have a lawyer when he pled guilty and paid that fine for that misdemeanor offense, was that he was supposed to file and submit a notice of withdrawal of suspension form to make sure his license wasn't suspended for the FTA. So Kevin leaves court. He thinks he's done his job. He's 19 years old. He starts driving. One day he's pulling out of his driveway, the driveway of his home. He gets pulled over by police in DeKalb County, Georgia, and they tell him, your license is suspended. You have to spend a night in jail. We have to incarcerate you, because that is the practice here. 1 night in jail, and then you get a court date, and you'll be charged with driving on a suspended license. He's 19. He's totally freaking out, crying, is incarcerated, has no idea his license was suspended, literally had no idea why that license was suspended. Spends the night in jail, nothing to prevent it, no public defender, goes to court 2 weeks later. The judge explains what happened, and he pleads guilty to driving on a suspended license. The judge sentences him to pay $800 and says, can you pay? And he's like, there's no way I can pay $800. Like, maybe I could pay a couple $100. Judge is like, no, it's $800. You can't pay. You're on suspension. You're on probation under the supervision of Judicial Correctional Services. Go to your probation officer, sign up for probation. You're going to have weekly meetings. Your fines and fees are due in 1 month. He's totally freaking out. He goes to the probation officer, says, I can't pay this. I was training to be a tow truck driver. The judge is now telling me my license is suspended. I can't drive the tow truck. I have no way of earning money. My family's really poor. And the probation officer just says, see me next week and show up with money. He goes. This is a client who goes to probation 4 times. Shows up every single time with $10, $20, $35, borrowed from his mother, borrowed from his sister, raked leaves. This was not a hard story to find. And he pays $85. Now, at the same time all of this is happening, the court that sentenced him knows that we're investigating them for running a debtor's prison. Human Rights Watch has issued a report on for-profit probation that came out in February 2014. At this point, it's November, right? So it's 10 months after Human Rights Watch talks about for-profit probation companies abusing people who can't pay fines and fees, about how these profit-oriented companies are being used by municipalities to generate revenue, and they're doing it in ways that lead to people being jailed without lawyers, without ability to pay hearings just because they can't pay. Totally exposed. It's on every radio station in the Atlanta Journal-Constitution. The newspaper sends a reporter to investigate this court, the DeKalb County Recorder's Court, which is one of the biggest courts in the state handling low-level offenses. And we did public records research with Human Rights Watch, which showed this was the court that made the most money off of using for-profit probation companies to raise revenue. This was a multi-million-dollar operation from this one court alone, and this company was working throughout the state, but this court was the biggest. So a couple weeks before Kevin goes to court and gets sentenced to probation, the Atlanta Journal-Constitution goes to court and reports on the fact that there was a hearing of 300 people who were being charged with probation revocation because they couldn't pay fines and fees. And the judge was just kind of going through them, processing them, jailing people who couldn't pay, and people who could pay were let go, and just kind of, they literally called it a cattle call. So Human Rights Watch had already exposed this. The Atlanta Journal-Constitution had already exposed this. They knew we were investigating, and what do? They call Kevin back in after 30 days. The judge says, the same judge who's documented by Atlanta Journal-Constitution and Human Rights Watch says, where's the money? And he said, I paid $85. I can't do anymore. If I could get a temporary driver's license, I could go back to training and I could pay the money. I just need a little bit more time and a driver's license. And the judge says no. He's taken away in handcuffs, crying in front of his mother. And you can hear it on the audio. So this is what our justice system has become. It's not a hard story to find. I get emotional. So we sue. And his story is on the front page of the Atlanta Journal-Constitution. And a week after we brought this lawsuit, we and the Southern Center for Human Rights supported House Bill 310, which was going to, for the first time, encode into statute what did not need to be encoded because it was already required by the Constitution, which is you have to hold an ability to pay hearing before you jail someone who can't pay, and also put a cap on private probation company fees. Now, we were going for no fees ever if someone's on probation just because they can't pay. What we ended up getting in the statute was a 3-month cap. And there were also guidelines for determining ability to pay and alternatives to incarceration and things like that. The law was not perfect, but what ended up happening was the court that we sued was dissolved. The legislature just decided to dissolve it. So it disappeared. The cases were transferred to another court, and a year later, the Atlanta Journal-Constitution did a follow-up investigation where they saw that the average fine had decreased by $150. What happened to the judge? The judge was, because the court was dissolved, just not a judge anymore, and wasn't appointed to the next judge. To the next court. So, I mean, and I will say, like, it was, on the one hand, we were not trying to demonize that judge as an individual judge, because I think, like, the bigger picture is that these incentives and these structures make people into bad judges, right? Like, it wasn't about her, it was about all of this. The idea that you could treat someone like this and just not even care, and not even blink an eye, that you were sending this 19-year-old kid into the criminal justice system because of his poverty, and now that's on his record, and now he's been jailed twice. How does that feel? In the end, it's a great story because we did settle the lawsuit. It was a damages case, in part because they knew we were investigating them, so they kept mooting out all of our plaintiffs with standing for injunctive relief. But we got a settlement, and Kevin was able to start his own tow truck business. Isn't that great? So great. But there's still a lot of work left to do in Georgia. So Kevin got a hearing, right? He went to court. He was sentenced by a judge who was a lawyer. Kevin also got a probation revocation hearing. Oh, I didn't even tell you the juiciest bit, which is that the probation officer, you guys will hate this, the probation officer, when charging him with revocation for non-payment, said to him, this very blasé, it's quoted verbatim in our complaint, "So, do you want a public defender?" And Kevin said, "What's a public defender?" And the probation officer said, "Oh, that's someone who you can pay to speak up for you, but you have to pay." That was a claim. Unlawful waiver of the right to counsel. And they gave him a form, pro forma waiver of right to counsel form. He had no idea what he was signing, and he signed it away. He had no idea that you could have someone stand with you in court and explain all of this stuff. Someone who could have stood with him to say, this guy just needs a temporary driver's license. There's a mechanism for that. Why can't we do that? Or how about we just waive his fines? Because he worked so hard for 4 weeks and paid $85 and showed up at probation 4 times without having a driver's license, hustling rides, getting his mom to drive him before and after work, right? Like, doesn't that show effort to kind of comply with your sentence? So he didn't know he had the chance to have someone stand up and talk for him, and it was really kind of, we see this a lot. It's like very emotional for our clients when they realize they had a right to counsel, because we always find them when they didn't have a right to counsel. They had no idea. And then they find out they had a right, and it just brings them to tears because they couldn't conceive that someone could have stood by them. So Kevin had some semblance of a process. I'm going to tell you about our other client, who we're currently representing, Marche Chindi Brown, who's right here. Marche Chindi is on the right, and Kaisha Johnson's on the left. So Marche Chindi is a mom living in South Carolina, a single mom, and about a year and a half ago was working at Burger King. And she was working at Burger King, and Burger King kept bouncing its paychecks. So Burger King would give her a paycheck, and then she would go to cash it, and there was no money because Burger King was insolvent. So she's struggling with all of this, and she doesn't have a driver's license. She's never had a valid driver's license, which we see as is a challenge in certain communities for a variety of reasons. She gets a ticket for driving on a suspended license, her first offense. Goes to court, She knows she has to pay some kind of fine. She totally goes in thinking, I did something wrong and I need to do something about this. She also got a tag light ticket. She goes to court. She's sentenced. In South Carolina, the fines are outrageous, outrageous. And actually, I misspoke. This was her second offense. It's her second DUS offense. And no public defender in the room. Judge is not a lawyer. This is in the Irmo Magistrate Court in Lexington County, South Carolina. And as Jeff and I talk about this a lot, this is the county where Dylan Roof is from. It's like DeKalb County, very wealthy actually for the state of South Carolina. DeKalb County too, second richest county in Georgia that was jailing poor people. Not a poor jurisdiction. It's the home of Emory University. Lexington County is right next to Columbia, and it has just like DeKalb, has a poor black side of town, and then a very wealthy white side of town. And the Irmo Magistrate Court is like right on the border of Columbia. She goes to court. There's no lawyer there. She has no concept that she has a right to a lawyer. They give her a form. She has no idea what it says. It says, do you waive your right to counsel? She just signs it. No one explains to her what it means. The judge is not a lawyer. The police officer is the one who's prosecuting the case. It's a completely lawyerless court. She pleads guilty to driving on a suspended license, second offense, and to driving with no tag light. The judge sentences her for driving with no tag lights, around $200, and then sentences her to driving on a suspended third offense. The difference in the fine is from $300 to more than $1,000. So she ends up with a total fine of $2,400. And she's thinking, as many low-income folks do, almost all my clients have this view. They're like, I want to pay. How do I make it work? What can I say I can pay? And the judge says, do you have the money? And she says, no, I don't have the money. The judge says, how much can you pay today? And she said, I don't know, like $50? The judge said, no way. I want my money. I want $100 on the 11th of every month. And she said, Your Honor, I can't pay that. I have 7 kids. And the judge said, I don't care how many kids you have. 1, 2, 3, 4, 5, 6, 7. I want my money. I want my money on the 11th. And we've gone into court and we've observed this judge. We have another client who was also 2 other clients who were sentenced by this judge. This is what this judge says. To another client, the judge said, if you don't pay, I'll have a warrant out for you faster than your head can spin. And she's terrified because the judge is basically telling her, if you don't pay, you're going to jail. And she leaves with a $100 a month payment plan, which is going to take 2 years. For 5 months, she makes the payments, even though the Burger King checks are bouncing, doing her best because she knows she has to prioritize that payment or she's going to jail, and her kids will not have a mother at home with them. Her son ends up having to get surgery on his jaw. He has an accident at the workplace, has to get surgery. She needs to take care of him. She cannot go to work, so she can't earn money that week. Burger King's checks then finally just go kaput. There's no more money. Like, she's not getting paid for her work, so she needs to find another job. So then she's totally unemployed, terrified of going to the court because the judge said, if you don't have my money, I'm going to jail you. And what happens? A couple months later, officers show up at her door, Saturday morning at 7:30 a.m., and her son opens the door. Mom, the police are here. She gets out of bed, 7:30 in the morning, gets out of bed, goes to the front door, tells her son to take out the trash because she doesn't want him to see her get handcuffed. And she's jailed for 57 days. Because that's what happens in South Carolina. Kevin was jailed for 5, which was terrible, horrible. What happens in South Carolina is you get the full sentence. It doesn't matter how much you paid towards your fine, you get the full sentence. It's wrong if you're jailed for 1 day. Think about the impact on your life when you're jailed for 57. So Marcinda's biggest fear was that her 13-year-old was going to be taken by child welfare services and that she was going to lose her child. Fortunately, she had an older child who was able to make sure that it was clear that this was not a minor who was being left without a guardian. She lost her job. She had just gotten a job about 2 weeks before in a food processing plant, and the Monday after her arrest was the day she was supposed to become a permanent employee, and she was supposed to get a raise. And she couldn't even pick up that paycheck. And she was really stressed about this because she knew that her family needed that money to pay the rent and the light bill. And so she's in jail trying to figure out, how do I get in touch with my family so I can help make sure that they're connected to the right people who can help them at least keep the bills paid. And she also had a choice. I mean, she had a little bit of money, and she was thinking, maybe I should give a little bit of money because then I won't be jailed and I can be with my family. Like, what should I do? Turns out in her jurisdiction, they didn't want a little bit of money. They wanted the whole thing. She owed $1,900. She couldn't pay. She went to jail for 57 days. We met her on day 10. And she was the one where we told her, that should never have happened to you. And she just started crying. Had no idea she had to write to a lawyer. No idea that the judge, she knew it kind of felt unfair that the judge didn't ask her about whether she could pay, but she didn't know it was a constitutional right, right? And I think like it's almost more difficult when people know how outrageous these practices are. And she is one of 7. The people we represent in this lawsuit against Lexington County, which we brought on June 1st, they were all jailed for periods of time ranging from 20 to 63 days. And one person who we sued when he had not yet been jailed was jailed 4 days after. So just as we predicted, that he was going to be arrested on a warrant because he didn't have the money, he couldn't pay in full, was taken off to jail. And we know what those consequences are. That plaintiff also, like, he suffered from terrible medical situation and ended up having to be taken to the emergency room and hospitalized, and was released from jail, from the hospital. The consequences are huge. I tell my clients stories, but I think that is what should motivate all of us to think about total system change. So what is the difference that an attorney can make? If someone was standing next to Kevin, that attorney could have explained that he needed a temporary driver's license. Someone could have explained that what he did satisfies what the Supreme Court required in Bearden versus Georgia, which is a showing that you've made bona fide efforts to pay your fines and fees. Someone could have argued that what he had done satisfied that mandate to look for alternatives to incarceration. For Marche Chindi, I mean, the consequences were so huge. An attorney at sentencing could have said, this person cannot pay. That attorney could have filed an appeal of that sentence, right? $2,400, an incorrect sentence for an offense she wasn't even charged for. Her ticket says DUS second. Her sentence is for the amount of money that corresponds to DUS third. It's statutorily invalid. All of those arguments could have been raised, but none of them were made. And so one of the core claims in the case that we brought against Lexington County is that there's inadequate indigent defense, inadequate funding from the county, but also the public defender's failure to even put humans in those courtrooms or even have them go to jail the way that they do for folks who are charged with felony offenses. Like the public defenders in Lexington County, they go in there when they know that someone's been charged with a felony. They at least make an effort to see them before they go to General Sessions Court, but that never happens in these misdemeanor courts after someone's been arrested for non-payment of fines and fees. And even having a court hearing then could have prevented a 2-month-long incarceration that really, really derailed Marche Chindi Brown's life. So the core cases here, I've offered you guys in your materials Bearden versus Georgia. Probably most of you have already heard about it, but just to kind of reiterate, it's key. You get an ability to pay hearing before you can be incarcerated for non-payment. You also have a right to counsel, depending on the precise procedural context. It could be the 6th Amendment or the 14th Amendment. I've listed on the back of the syllabus some of the core cases there. There's Argersinger, Scott versus Illinois, Alabama versus Shelton. In the South Carolina context, what we're seeing is a lot of folks are getting these suspended sentences. And they have a right to a lawyer then, and it seems like no one cares or acknowledges that even exists. But that's core law. We've talked a little bit about this protection, this due process protection against decision makers who have a conflict of interest. That's huge as well. And then there are additional safeguards. I think state law is really important here. Each state has a different system, as you well know, for determining what ability to pay means in the right to counsel context. And a lot of that can be used to apply to the ability to pay context in the fines and fees space, especially where there's no independent rule on point. States like Washington, states like Ohio, Michigan, they already have standards for what it means to be able to pay or unable to pay. Georgia, as I mentioned before, they already have these standards. New Hampshire also joined the list. Lots of states are moving, which is good. But in places where those rules don't already exist, you can borrow from the rules that are in place for the appointment of counsel. And it's really important to know, what all of those rules are. Are folks here working in civil court at all? Is anyone here doing straight up legal services? Okay, no, you're all defenders. Okay, so we don't need to talk about that. But there are rules, and we have arguments for why there's a right to counsel there as well, notwithstanding the Supreme Court's decision in Turner versus Georgia in 2011, which held that there was no right to counsel in the child support context. So I'm going to actually fast forward. This is something I would actually, if you have it, just please pull it out. I think it's super important. This is a guide for public defenders that we put together. A guide for public defenders defending indigent clients from the imposition and collection of fines and fees. And I think this is something that's evolving, and we're constantly improving it based on our conversations with defenders on the ground in different states. And we've made state-specific models in certain places, like Mississippi. We're in the process right now of creating a whole toolkit in the state of South Carolina, like model pleadings, motions, this is a 2-page guide that anyone can take with them to court, and that walks you through the main things to think about when you're representing a client, both at the trial, conviction, sentencing stage, and later in the case when that person might be subjected to collections of their fines and fees. And so I want to hit a couple of points on this, because I think it shows how folks can be useful. Some of these courts have no public defenders, and some of you can be crucial, vital proponents of extending access to counsel to those courts where counsel isn't already there. You may work in a jurisdiction where there's a system like what I was describing in Lexington County, where for folks who are charged with felonies, there's some kind of structure and process to put people in touch with defenders pre-trial, but that structure doesn't exist yet for the courts of limited jurisdiction that handle traffic offenses or misdemeanors, where people could be saddled with these super hefty fines and fees like Kevin and Marche Chindi were. And you can advocate for extending the right to counsel, and I'll give you an example. Right next to Lexington County, South Carolina, is Richland County, South Carolina. And the difference between those two offices could not be more stark. In Richland County, the public defender, the chief public defender, and the line public defenders fight to get in to the magistrate and municipal courts, which are the courts of limited jurisdiction that handle only traffic and misdemeanor offenses. In Lexington County, the public defender never sends anyone there. There's no structure for it. No one's assigned to ever do it. It's a non-issue. In Richland County, the public defender is fighting for more resources from the county council to extend that representation. That's not happening in Lexington County, and that's part of the reason we sued Lexington County. In Richland County, public defenders are actively encouraged to go to trainings like Gideon's Promise. And it's no surprise that in a defender's office with 4 or 5, I believe, junior defenders who've been to that really intense institute, Gideon's Promise, which I think most of you guys have heard of, they are out there. They are filing motions challenging the imposition of fines and fees. They are doing things to push and test the boundaries. When the judges don't want to appoint them, they try to get appointed, even though they know the judges will get mad at them. And these are sensitive, strategic decisions that have to be made, because obviously defenders want to make sure that their clients get the best representation, and they don't want to piss off judges left and right. But there's a cultural difference between these two offices. In Richland County, the public defenders go into jail and they talk to all sorts of people, whether they're arrested for felony offenses, for misdemeanors, or on a bench warrant, which is a warrant used to enforce a payment obligation. They're out there, they're having those conversations, they're trying to get on those cases. In Lexington County, that's not happening. So there's so much that can be done, even if you feel that you are a small part of a system and that you can't change the system, so you can't force the court to require appointment of counsel in these lower cases, you can actually do a lot to raise a stink and take it up the chain and try to get that representation extended and raise awareness about this stuff. You could share information about the Lexington County case with the other folks in your office. And this is just one of many cases. I would be happy to send you a list of 20 cases around the country in the last 5 years that have challenged right to counsel in this context. So as a threshold matter, there's a lot that can be done structurally, even from the position of a line public defender, to challenge the status quo in a place where counsel is not a given. In those courts where you are, when you're representing someone, whether it's for a lower level offense or a felony offense, thinking early and often about criminal justice debt and the consequences, with the nuance and strategy and careful thoughtfulness that you bring to your work, is really crucial. Obviously you don't want to get your client sentenced to jail because the person can't pay. But there are ways to raise the argument of inability to pay even at imposition, and there are states and local jurisdictions where there is a right to an ability to pay hearing at imposition. The wonderful state of Washington made this a requirement in its decision, the Blazina decision. There are other states that have statutes that require an ability to pay determination. One of the key things to look at as a lawyer is when you're representing someone, figuring out what are all the possible penalties and which of those penalties are fines, which are imposed for punishment, versus costs and surcharges and assessments. And in your specific jurisdiction, there may very well be case law or statutes that explicitly require an ability to pay determination for costs. And there's Supreme Court authority for that position. This is Fuller versus Oregon, James versus Strange, that the idea that costs should not be imposed unless someone has a foreseeable ability to actually pay them. It's a completely legitimate argument to make, right? A cost is not a fine. A cost is not part of the punishment that someone should get for their offense. The cost is the added result of all the things we talked about, of this court revenue generation, for-profit-minded companies, and structural racism to get money from folks who may not have it. So the fine also, in a state like Washington, also is subjected to an ability to pay hearing, but don't forget about that distinction between costs and fines. So I think I really would love it if folks would use the flowchart, give me feedback on the flowchart. If you think that this doesn't make sense for your jurisdiction for some reason, tell us. We want to know. Because what we're trying to do is to make tools that people can actually use in court. And the key parts of this, and I'll just highlight a few, is that, preparation. Like when you're representing a client and you're going to court, the court might ask your client about ability to pay, and you want to know about your client's financial circumstances, all of them. All of them. And clients are almost always optimistic about what they can pay because they don't want to say that they can't. It's embarrassing. It makes them feel bad. It's not something they're proud of. Who likes saying, I don't have money? It's terrible. And I think really having an honest conversation with your client about are you sure? Because that light bill is really big. I've never had a client who underestimated the amount of money they could afford to pay towards a fine or a fee. And then client counseling, really talking to your client about what it means to accept a plea deal, given the amount of money that's on the table. Thinking carefully about advocating for bifurcation, maybe doing conviction, trial, sentencing first, and then later, let's talk about a payment plan and ability. What can this person really pay, judge, and can you waive or reduce some of this within the boundaries of the law and the rules? I also gave all of you in your materials an excerpt from this really fantastic guide put together by the National Consumer Law Center, Confronting Criminal Justice Debt, which literally walks you through things to think about when representing clients at imposition as well as later in the collection phase. And it actually also includes statutes, ordinances applicable in different states that do require ability to pay determinations at imposition. And then finally, this guide also talks about after someone is sentenced to fines and fees, if they can't pay, making sure that your office is representing them through the course of their entire case, and that includes anything that's post-conviction related to collecting fines and fees, how to actually argue that your client is unable to pay. The good thing now is that, and even for places where there is no standard, there's no statute, there's no case law on point saying this is what it means to be able to pay, this is what it means to not be able to pay, there's now standards at a national level that you can point to say, look, this is a national guideline. In your materials is a bench card from the National Task Force on Fines and Fees. And this is a task force that was created after Ferguson. It is comprised of state chief justices as well as state court administrators. And they've endorsed this guide. They have endorsed a guide that says there has to be notice in advance of an ability to pay hearing, that someone has to be told and notified of their right to counsel, that at the hearing the judge should look into and consider whether the person makes 125% of the federal poverty line or less, whether the person has a mental health issue, if the person is incarcerated, if the person has other fines and fees, if the person has responsibilities to defend dependents. This may not be in the law in your jurisdiction, but you can point to this and say, this is now happening around the country. The state of Missouri adopted that bench card in full with no edits, and it's being used in every court around the state now. And so these are becoming increasingly normal things to ask for. And I'll just end on the note of alternatives. Just as fines and fees are not the solution to incarceration because they can lead to incarceration, same goes for community service. What we're seeing in certain jurisdictions is that there's a knee-jerk reaction to say, fine, if folks can't pay fines and fees, we'll just send them to community service, they can do public work, we'll translate the amount they owe using some formula, whether it's minimum wage or $20 an hour or $10 an hour, to a certain number of community service hours. Well, think about Marche Chindi, who owed $1,900. If that was translated at community service at a rate of $10 an hour, she's looking at 190 hours of community service without a driver's license, without a job, and with 7 kids. Not reasonable. The most accessible alternative to jail and fines and fees people can't pay is just meeting them where they are. Just get that number down to the $85 that Kevin Thompson was able to pay, to the $600 that Marche Chindi had already paid towards her fines and fees. And that is in the language of the Supreme Court's decision in Bearden itself. It says, Justice O'Connor, not a trailblazing liberal, right? Justice Sandra Day O'Connor said, a court cannot jail someone without looking into reasonably available alternatives to incarceration, including waiver and reduction of the amount owed. We can use this as advocates. We can say, Justice O'Connor wrote in Bearden versus Georgia. And these arguments work. And the more we make them, the more they work. And I'm excited that folks like you guys are energized and gonna take this information to your jurisdictions. If you see problems, if you see debtors' prisons, you are in a place where people are facing mass revocations of driver's licenses because they can't pay fines and fees, call the ACLU, call civil rights organizations. We want to know. These are things that we're actively challenging in different places. And even when we're not bringing affirmative civil rights litigation, we want to arm people with tools. We want to make these things usable so you can go in and do your jobs as advocates to promote a more fair and equal justice system.